Well, I mean, you could benefit through percolation and a decision from this court with reasonable expedition.
So I have no objections to reasonable expedition. We would have no objection to this court even setting supplemental briefing on the merits and hearing the merits directly. I'm happy to talk about the ways in which I think the merits do bear on this emergency application. But more fundamentally to your question, Mr. Chief Justice, I would just note that I don't think the alternatives actually fully remedy our injuries in a couple of different respects. So I heard my friend on the other side to specifically say today that maybe there can be an instruction to the federal government that at least when you're dealing with the plaintiff states, you treat these individuals kind of as though they're citizens, even if they're not really citizens. And that doesn't work, not just for the federal government. I agree, Justice Gorsuch, it may well be that the federal government can decide when to take its own medicine, but I'm talking about administrability burdens on the states, and I'm talking about administrability burdens on third parties as well.
Can I ask you a question about that, counsel? Your three buckets are very thoughtful. The first one seems to me kind of consistent with traditional equity, which is if it's required, if you've got to remedy the plaintiff's harm. That's your point there, and you're saying we fall in that bucket. I get that argument. The second bucket is possibly Article 3, okay, that Congress could authorize, and maybe has authorized circumstances. But that doesn't answer the equity point. So we come to bucket 3. And I'm struggling to understand what the rule is there. You seem to suggest, well, if it's really important and if you have to act expeditiously, then go ahead. But I think every district court who enters one of these thinks that's what they're doing. So what's the constraint there if you share the government's concerns about the rise of these things in the last few decades? What teeth does any of that have?
So I do feel like something of an amicus to this question because nothing in my injunction rises or falls on this third bucket. So I'm happy to answer questions.
I need all the amici I can get.
Fair enough, Your Honor. So I would say two things about that. The first is it does require reading the history in a way more like I do, which does not create a single bright line rule that this is never available. Obviously, if someone reads the history as saying it's impossible.
I'm spotting you that for the purposes of my question.
Great.
I'm not granting
I thought you might not, Justice Gorsuch.
But I'm spotting it to you, and I'm just saying, well, okay, what would that look like, and how would that be any different from what we have experienced over the last few decades?
So this is a way in which my first bucket and my third bucket are actually going to relate for a moment. So I think this is
no.
It's helpful, I promise.
Don't get to squiggle out into the first bucket, okay? We're in the third bucket.
I'll answer for the third bucket, which is I think it requires having district courts consider the availability of the alternative and explaining why it's not workable in the case.
I think we've told them to do that, and gosh, how many times do we have to tell them to do that? And I think, in fairness to them, that's they think they have. So let's, again, would any case over the last 30 years come out differently under your view of the rule in the third bucket than has?
Yeah, so there's a couple of examples where we don't think universal relief was appropriate. I'm most familiar with the state litigation, so most of my examples will probably come from there. But I heard my friend on the other side mention the DACA litigation, where Texas sought the termination of DACA, and ultimately the Fifth Circuit terminated DACA specific to Texas alone. And we thought that that decision was exactly right because of the nature of the harms in that case meant that Texas could get full relief for its harms.
Well, now we're back to the first bucket. We're just satisfying
I take the point. I'm so
you
sorry.
See what I'm saying?
I take the point. Yes.
I mean, I get that we're going to always revert back to the first bucket, but that means the third bucket's empty.
I totally take the point. I think AARP is a good illustration of the third bucket that this court confronted recently, where it was the case that there was this rush, just a few hours, not possible to go through class certification. You heard my friend on the other side talk about the rigors of class certification, and I don't think my friend on the other side would agree. It could be done in 3 hours through the night, and so there were necessity to step in.
Do you agree